The difference between a trademark lawyer and an online trademark service. So many people think a trademark application is a pretty straightforward administrative process, and so why not use one of these online trademark services to save money? Why pay more when you can pay less? And you know, that makes perfect sense. If it's the same thing, I agree, why pay more when you can pay less? The problem is that it's not the same thing, but unless you have done this before or know someone that has, you won't know that it's not the same thing, or you won't appreciate how different it can be. One of what we find is that very often people that start out trying to save money, they end up wasting money and spending at least as much as they would have spent with a lawyer, if not more. So it's sort of like if you've ever used one of those travel sites that promises a super cheap airfare, but then you find that by the time you buy the ticket and you pay for all the necessary add-ins like luggage and a seat assignment and all these extra fees and taxes, by the time you get to the end, you're paying the same amount that you would have paid if you were just using a major airline, except you're not getting the major airline experience. You're getting nickeled and dimed all the way, and it's a hassle. And then you end up sitting on an uncomfortable seat. It can be very much like that, where you get started thinking it's going to cost you one thing, and then by the time you're done, it ends up costing a lot more. Because really, keep in mind that these are not law firms. These are software companies. They're designed to collect fees, and so they're set up in a way that could be really misleading. So for instance, there's one that says you can only have one class of goods per application. A class would be like it's common to do like a trademark where you have maybe coffee mugs, apparel, t-shirts and hats, and stickers. So that would be 3 classes of goods at the USPTO. So on some of these things, these services, they will make you file 3 applications because they say you can only have 1 class of goods per application. That's not true. It's just true in their world. So if you go to a lawyer, we would do that as a single application. That's a single legal fee with 3 costs. The costs are just whether you do it yourself directly, you're going to pay the costs, the USPTO costs, which currently are $350 a class. So that brings me to my second point, is that when you're using these online services, you're basically doing it yourself. You're getting minimal to no guidance. Sometimes you're getting guidance that's misleading. So if you're going to do it yourself, you might as well just go straight to uspto.gov and literally do it yourself and save those extra fees. Another thing that I wanted to point out is that they do this searching sometimes. They will say, congratulations, it's available. And that searching that they do, it's not real clearance searching. What they're really doing is just checking your exact trademark. And so it can be highly misleading, and it can lead people to file applications and adopt trademarks that they cannot register and might actually get them sued. Because again, that trademark searching is not clearance searching. You're not getting a legal opinion, and the way trademarks work, it can be pretty different and still be a problem. So it can still be a conflict, even if it's not exactly the same. So keep in mind that searching is not clearance searching, and you could end up adopting a mark that is dangerous, or at best, not registrable. We actually have a regular inflow of work where it comes to us because people got started and they got themselves in trouble with rejections they don't know how to get past. And sometimes those are things that we can fix, though it ends up costing them more. When we end up having to fix it, it ends up costing them more than if they had just started with us in the first place. Those are the better situations. Sometimes there are problems that we can't fix because of the way the rules are, so we have to file a new application. And that not only does that cost more, but it also means that they lose the priority of the one that they filed. And that can be fatal in a trademark project because it's first come, first served. The trademark goes to the first person. And so if it took them a year and a half or a year to get to the point where they're coming to us and we have to refile, they've lost a year of priority. And if someone else got in there before them, that person could end up owning the trademark and not them. They could lose it. So again, there are these little traps. It seems like you're saving money, but very often you're going to end up wasting money and sometimes getting yourself in trouble that is going to end up costing you a lot more not just in money, but also in opportunities. So keep that in mind. And please, if it's something that's important to you and it's important to your business, invest a couple $1,000s and go to a lawyer. Even if it's not us, there are other great lawyers out there. Just make sure that you're dealing with someone who actually you can look in the eye and is able and willing and caring enough to have a conversation with you about what's important and how to actually get you the protection that you need. So Catherine Cavella, IP Works Law. Thanks.